Last year I did present on occupational health and safety and the application of occupational health and safety to professional sports. At that presentation, I think it's fair to say that some people were surprised about the application of occupational health and safety laws to professional sports and taken aback at the idea that a health and safety regulator would prosecute a professional sport for the manner in which it managed its players. At the time I spoke, I said that the regulator was very reluctant to get involved, but I thought they should. And as things evolved, they did. I'm now going to talk about the application of occupational health and safety laws to major events more broadly. This is an area, though, where the regulator will not be reluctant to get involved. This is an area where regulators have already been heavily involved because of the nature of the event. It's high profile, the number of people involved, the risks that are involved are not unique to sport. Running a major sporting event is, in a sense, a major industrial and conglomerate exercise. It's construction, it's building infrastructure, it's transport and logistics, it's hosting an event, it's security, it's crowd control, it's food, alcohol, liquor, drink retailing, it's cleaning, it's waste management. These are the things that occupational health and safety regulators do day in, day out as their regular business. So as I said, it's not an area that they will be reluctant to be involved. But it's also an area that's important because, unfortunately, things can and do go wrong at major sporting events. There have been no shortage of disasters at major sporting events which raise occupational health and safety issues. On this slide, there are two disasters, 70 years apart at the same stadium. The first involved a collapse of a grandstand, 25 injured, 25 dead, 517 injured. I should say the pictures get a little bit more graphic after this, so a warning. The second one, a crowd crush at a Rangers Celtic game, 66 dead, 200 injured. Burnden Park, another stadium in the UK, a human crush, 33 dead, hundreds injured. The Bradford City Stadium fire in 1985, 56 dead, 265 injured. The Estadio Mateo Flores disaster in 1998, a FIFA World Cup qualifier between Guatemala and Costa Rica. 83 killed, 140 injured. They called it a human avalanche as a result of allowing too many people into the stadium. Another one was an Ellis Park disaster in Johannesburg, a stadium with a capacity of 60,000. They let 120,000 in. 43 people died in the stampede when a penalty was awarded and everyone wanted to rush forward to see the penalty be taken. Doesn't have to be mass fatalities though. The Melbourne Grand Prix in 2001, track marshal Graham Beveridge was killed when Jacques Villeneuve crashed and the tyre left his car and went through a gap in the trackside barrier. Sometimes it's political. We had a Port Said in Egypt, a stadium riot, 74 dead, over 500 injured. And it doesn't have to be even a fatality. For those who may have seen the final of the Football Federation last year, Frank Lowy fell off the podium where the trophy was being awarded, landed on his head. He's an octogenarian, he got up. I wouldn't have got up from that fall. Tough old man. But what we see is that things can and do go wrong. And what I want to do today is talk about the health and safety implications of these things, but more from a preventative viewpoint. But in order to be preventative, we need to understand why things go wrong. And so I've just developed a simple topography of disasters. It's not very scientific, it's not very rigorous, but just a very quick one. And what we see is, though, that there are risks to the participants, there are risks to the patrons, the paying people who pay, but there's also risks to the public, particularly as more and more major mega sporting events are taking place within the cities where people who aren't paying to attend are still impacted. And we can see that a disaster can be caused by an act of God. They're by far in the exception. Most of them are man-made. And they can be a result of negligence, poor planning, poor design, poor implementation. I don't use the word accident. I come from a workplace health and safety background. We don't believe in accidents. Things just don't happen. Men cause them to happen, and women. I use men in the generic. Or it can be deliberate. It can be deliberate, it can be as a result of an intentional act to cause harm, such as a terrorist act or a riot. Or it could be recklessness, antisocial behaviour, misguided exuberance, the flare in the stand. So I want to talk, as I said, about health and safety in this context that things can and do go wrong, and more often than not, when they do go wrong, humans cause the problem. And I'm going to use a case study to illustrate the application, and given I'm here on the beautiful Gold Coast and we've got the Commonwealth Games coming up, I'm going to use the Commonwealth Games as my case study to illustrate the application of the occupational health and safety laws, because it's also very good because the complex nature of the Commonwealth Games gives a very rich factual matrix within which to explore this. And I should say, and I don't know if there's anyone here who's involved with the Commonwealth Games, I'm working off the Commonwealth Games website and their most recent annual report. And so if I've got anything wrong and anyone knows better, please let me know. But where do we start in organising the Commonwealth Games? Well, it starts with the Commonwealth Games Federation. This is an international association related to but separate from the Commonwealth. And it awarded the Commonwealth Games to the Gold Coast on the 11th of November 2011. And I have done a bit of searching on the web and a couple of places to try to find out the nature of the Commonwealth Games Federation, and it eludes me. I assume it is just an informal association with no legal status whatsoever, because I couldn't find anything that tells me otherwise. And they awarded the Games to the Australian Commonwealth Games Association, the Queensland Government and the City of Gold Coast. They were the three bidding entities. The Australian government supported it, but the Australian government was not a bidding entity. And they got it on the 11th of November 2011, and they must have been very confident because on the 1st of January 2012, the Gold Coast 2008 Commonwealth Games Corporation was established, GoldDoc. And GoldDoc is the organising committee. And its job is it's an independent statutory authority created under statute, and its function is to undertake and facilitate the organisation, conduct, promotion, commercial and financial management of the Commonwealth Games. So it is the primary organiser of the Commonwealth Games, but it doesn't do it on its own. It partners with a number of other government agencies, and this is by no means exhaustive, just some of them. Within the Queensland Government, there's the Office of the Commonwealth Games Coordination that coordinates all Queensland Government input into the Commonwealth Games. Its equivalent at the federal level is the Australian Government's Population, Health and Sports Division within the Federal Department of Health. It coordinates all federal government input, everything from immigration, customs, intellectual property law, terrorism, security. The City of Gold Coast contributes. It's responsible for the arts, cultural, and interestingly, the legacy activities are the responsibility of the City of Gold Coast. Then there is the Commonwealth Games Infrastructure Authority. And it is responsible, as its name would suggest, for providing ensuring the infrastructure is provided, the village, the venues are provided. I should mention, within the Commonwealth Games coordination, that's in the Department of Tourism, Events, something or other. The one department I didn't put was the Queensland Department of State Development, which is responsible for project and contract management. But what you see is there are a number of government agencies that are involved in delivering the Commonwealth Games. But they also don't do it on their own, because they don't have the expertise and the capacity to do everything that's needed to run a Commonwealth Games. So they employ contractors. They employ contractors from everything from the Grocons and the major construction companies to build the new venues and to renovate the new venues. They retain contractors to supply the vehicles that are needed to transport people, to build the roads, to build the rail, to build the new train stations. They employ the contractors to do the logistics, the transportation, the storage, the warehousing. And then when you go to the event on the day, there'll be a contractor providing the security, the crowd control. There'll be a contractor selling you your drink, your hot dog, your beer. And then there'll be another contractor afterwards who's going to come up and clean up after you and make sure the amenity is clean afterwards for the next day's crowd. So there are all these private sector organisations involved in running the games, and they employ people. Or they have labour hire workers. These companies, the governments employ people. And then there's going to be an army of volunteers to make sure everything happens. But they're not the only people. We've also got the participants, the patrons, and the members of the public who are interacting with venues and things. So what you see is that the Commonwealth Games is an incredibly crowded space. Incredibly crowded with lots of people doing lots of different things. And I know on Commonwealth Games Day, when you go into the stadium, it might be the stadium just across here, and you walk in the stadium, all of these people, all of these organisations and the people they employ, in one way or another have had a role in ensuring that you have a healthy and safe experience. And so the question then rises inevitably, particularly because I'm a lawyer and we always get involved after the event, when something does go wrong, who do we blame? Which one of these people owe duties, and I'm going to look at it only from the occupational health and safety laws, but which one of these people owe duties and what do those duties require of them? Now this is a very busy slide and I'm sorry for the people at the back, but what I've done on this slide is summarise the work health and safety duties under the Queensland Work Health and Safety Act. So this is only looking at under the Act. As you're looking at it, the left column are the people who owe duties. And Queensland primarily imposes duties on persons who conduct a business or undertaking. And in the conduct of the Commonwealth Games, the previous slide I showed, I don't know if I can go back here, yeah. Who are the people conducting the business or undertaking of the 2018 Gold Coast Commonwealth Games? Well, I would suggest to you it's everyone down this middle spine. The Commonwealth Games Federation, the bidding entities, the organising committee and the partners of the organising committee, the government agencies are all in the business of providing the undertaking or conducting the business of the Commonwealth Games. As are the contractors. Their business might be building the particular stadium for the Commonwealth Games, but they are oversighting a business or undertaking that forms part of the Commonwealth Games. So all these people whose business or undertaking is providing, organising and facilitating the Commonwealth Games owe two key duties. The first duty is to ensure, not try, but ensure the health and safety of workers. Ensure the health and safety of workers qualified by the words so far as is reasonably practicable. So the first duty is to the workers, ensure their health and safety so far as is reasonably practicable. That's the notion that we traditionally understand occupational health and safety laws to be about, worker protection. But there's a second duty. Ensure, so far as is reasonably practicable, that the health and safety of other persons is not put at risk from work carried out as part of the conduct of the business or undertaking. So they have a duty to other persons being persons not workers. And that's where the public safety obligation comes in. They have a duty not just to the workers, but to the participants, the patrons, and the public who might be put at risk by the conduct of the event. There are other people who owe duties, and I'm not going to go through them all now. We don't have the time, but I think this will all be put up on the web eventually. But the people who design and manufacture the plant and substances. That's defined very broadly. So that will be the people who design and build the venues, the architects, the construction companies, as well as the people who build everything within it, the lifts and all of that. The people who control and manage the venue on the day, the directors and officers of those organisations, the workers, the employees, even the volunteers owe duties. You volunteer, you think, I'm going to get a nice tracksuit, a nice t-shirt, I'll have a nice day. Well, you're taking on some responsibilities as well. And interestingly, other persons at the workplace must take reasonable care, sorry, I've dropped the care off there, that his or her acts or omissions do not adversely affect the health and safety of other persons at the workplace. That is the participants, the patrons, and the members of the public. When you walk into the venue as a paying member, paying member of the public to see the event, you assume obligations under the Act not to behave in a way that could put other people at risk. So next time you take your flair into a soccer game, that's the duty you're breaking. So as you can see, there are lots of people who owe broad duties. And they owe broad duties with respect to the same activity. So the next question to be asked from a workplace health and safety point of view is, what is the nature of these duties and how do they operate in an environment where people owe the same duties with respect to the same activities? So in this picture here, if something does go wrong, who's responsible for what? Are there neat barriers or do they overlap? And what the law says is that the duties are concurrent, overlapping, and non-delegable. They're concurrent. People can owe the same duty with respect to the same activity. Multiple people, same duty, same activity. They can overlap. And importantly, they're non-delegable. The law makes it very clear you cannot contract out of your workplace health and safety duties. You cannot enter into a contract that says to the other person, you take my responsibilities. You cannot do that. And I've got a quote here from a Victorian case, but it's applicable to the same legislation as in Queensland, which says the duties are absolute. There is no defence of honest and reasonable mistake. There's no requirement to actually know that you're doing the wrong thing. There's no mental element to the offence. There is no due diligence of defence. It's not good enough to say, well, I did everything. You have to do everything to the extent to ensure it reasonably practicably. It's not a defence to say someone else's fault, not my fault. You've got to do everything that was reasonably practicable. So the question now to be considered in the context where we have an organising committee who are retaining private organisations, private companies, contracting out the construction of the site, contracting out the building of the railway station, contracting out the catering, the cleaning and the security. What do they have to do? What does everything reasonably practicable mean in that situation? And here the law gets a little bit bipolar, a little bit schizophrenic. Because the law starts off with the proposition that this is health and safety legislation. This is protective legislation. This is remedial legislation. It should therefore be given the widest possible interpretation. Interpret it generously, because we're here to protect people. But they say that with one hand, but then the judge goes, but at the other time, we're not expecting the wisdom of Solomon. We're not expecting you to be able to do the impossible. We've got to approach it as practical people. And central to this balance between its protective nature and its practicality is the concept of control. And what the courts have said is you have to act commensurate with your level of control you have over the activities. And if your control is limited, then what you can do, what is reasonably practicable, will be limited as well. So in this matrix we had of different players, you've then got to work out who has control over which part of the activities. And that can be very difficult. And indeed, people will have overlapping controls or multiple controls or different types of control. Someone might have a contractual right to do something, but someone might be the foreman on the ground with the operation. And what the law basically says though, what we're really looking for overall is to ensure a safe system of work and good risk management. And so the way I've started to kind of conceptualise this is looking at the principles, let's say the organising committee's level of knowledge and expertise versus the level of knowledge and expertise of the contractor they retain. And just to work through this, if and we'll use Goldock, the organising committee, for that. The organising committee has high levels of knowledge and expertise, and the contractor has high levels of knowledge of expertise. The principal cannot just delegate, because we know the duties are non-delegable, it just can't hand it over to the contractor. The principal is going to have to vet the contractor's systems of work and actively oversight them. It's got the level of knowledge, it's got the level of expertise, it's therefore required to bring that to bear to actively vet and oversight what the contractor does. However, if the principal's system If the principal has low knowledge and expertise compared to the contractor, then the principal only has to ensure that the contractor has an effective system of risk management in place. Doesn't have to vet it, doesn't have to actively oversight it as much as there, but it's still got to do something and ensure that there is an effective risk management process in place. The cases deal with these two categories. The cases don't deal with these. For completeness sake, if the principal's got all the knowledge and expertise and the contractor doesn't have the knowledge of expertise, my question is, well, why aren't you doing it yourself? And the other one is if they've both got knowledge, if the contractor's got low knowledge and expertise and the contractor's got low knowledge and expertise, why are you using that contractor in the first place? Get yourself a different contractor. I'm running out of time, so look very briefly, if in the situation where the contractor has low knowledge compared to the principal has low knowledge compared to the contractor, they've got to put an effective risk management system in place. What does that look like? It looks like good contractor selection. In the tender documents, have you got health and safety prominently covered in the tender documents? Are you getting them to tell you that they have the qualifications, the experience, the knowledge to do it? Do you have proper terms in your contracts to cover health and safety? A good risk management system in place. I'm not going to go through what that is. There's plenty of advice out there and much more knowledgeable people about risk management systems. A thing specific to workplace health and safety laws is a legislative requirement to consult and coordinate. So each individual duty holder that I had on their previous slide has a statutory obligation to consult and coordinate their safety activities with the safety activities of every other duty holder. So it creates a web, if you want to think of it, of people who have to cooperate and coordinate their activities. And you've got to acquire the level of knowledge to be able to do those things. So in a construction situation, you don't have to, GoldDoc doesn't have to require the level of knowledge to know about engineering stresses and engineering frameworks to build a stadium and know how certain welding has to be done. But they have to have the experience and the knowledge to be able to have a good tender document, to be able to review the tender submissions and make informed decisions. And finally, given my earlier comment about the regulators not being reluctant in this area, you should engage the health and safety regulators. I don't know the Queensland regulator very well, but I know in Victoria, where I come from, they actually have a major events and public safety division within the workplace health and safety regulator. And they proactively work with the Grand Prix and the tennis and the racing to do these things. And I'm sure the Queensland one would have, well, I hope the Queensland one has something similar. One final comment, just indulge me, it's a little bit of a tangent, but it relates to when we're talking about workplace health and safety laws, we're talking about guarding against workplace health and safety risks. We're not talking about guarding against financial risk. We're not talking about guarding against reputational risk. It's about workplace health and safety risk. But that can often get lost in professional sporting contexts, as I suggested got lost at the Essendon Football Club. And so my final thought is keeping that in the forefront of your mind. This is the Australian Rugby Union's snippet from the Australian Rugby Union's website giving guidance to rugby union clubs about health and safety. And they say, Go Gates, I assume, is their consultant, but the Australian Rugby Union have developed documentation tailored to rugby bodies to assist in providing a safe environment for all participants. We encourage you to download and use this document to promote a safe environment at your club. Tick, tick, tick. What's the thing guiding this document? The safety at the club, the safety of participants. AFL, let's look at how the AFL approach the same issue. This is their guidance to their clubs. Risk management is about being aware of what may happen at your football club and taking steps to limit the chance of it occurring. So far, so good. Risk is not necessarily harmful on its own, but left unaddressed can have significant impacts on your football club. So far, so good, although they haven't been specific about what the impact is. Then they go on. It is important for football clubs to undertake a structured approach to risk management so they can demonstrate to insurers and others they have taken precautionary measures to their insurers. Then they go on. Given the increasing desire of people to hold organisations accountable for their actions. Horrible. People want to hold organisations accountable. Who are they talking about? They're talking about lawyers. They're going to be sued. Because you might be sued, and the difficulty of obtaining appropriate insurance, risk management is a critical aspect of modern management. They've got their priorities wrong. The tail is wagging the dog here. And it's tempting to look at this statement and think about things that have happened at the AFL over the last 12, 24, 5 years and say, maybe it's not such a surprise that these things have happened if this is where they start from. The key issue from workplace health and safety is it's about workplace health and safety. That should be the priority. You can't have a successful Commonwealth Games, you can't have a successful mega or major event if people aren't healthy and people aren't safe. Thank you.